Okay, let's get started, I would suggest. So first of all, good afternoon and welcome to you all for joining us. Let's start off maybe with some practicalities as well. So during the webinars, during the presentation, please stay muted. That's easiest for everyone to understand each other, I think. And we also have some time to ask questions after each presentation. So if you wish to ask questions at some point, you can raise your hand or put your question in the chat and we will make sure that your question is answered. So welcome to you all and welcome also to this first webinar of the STRATEGO Jean Monnet Center of Excellence. And today's topic is debating EU and international environmental policy from agenda setting to implementation. So we have two presentations lined up for you today, but let's first kick off with a short introduction by Peter Bursens, who is the coordinator of the STRATEGO Jean Monnet Center of Excellence, and who will also tell you a bit more about STRATEGO. So Peter, the floor is yours.
Okay, thank you very much, Sophie, for the introduction. I won't take long because we are all here, of course, to discuss the research by Frederik and Andreas. But let me say a couple of words about STRATEGO that I coordinate here at the University of Antwerp. So this is a Jean Monnet Center of Excellence that basically deals with teaching, education, research and outreach with respect to democracy, trust, democratic governance, in the twin transitions, digital and green transitions in the European Union. So that is the broad agenda of the research center, of the Center of Excellence. And we organize a whole series of events with respect to those topics. In teaching, this means that we try to cooperate across disciplines, not only in the social sciences and law and economics, the usual suspects when it comes to studying the EU, but we also cooperate with colleagues in the medicine faculty and in the sciences faculty, so with biologists, for instance, as they obviously also deal with aspects of the green transition. So that is what we try to do, joint bachelor and master theses, guest lectures in each other courses, so that the governance aspects of those topics that are also studied in these other disciplines are taken on board and vice versa. And in terms of research, what we do is try to facilitate the collaboration between researchers and colleagues from these different disciplines and faculties by having lunch seminars and all kinds of get-togethers across disciplines, and this series of webinars, of which this one is the first that you are joining, is one of those examples. And Sophie will introduce the speakers to you and the topic a bit more. And finally, what we also try to do is some outreach. This is a dissemination of research results. So again, this seminar fits into that, but we also try to engage in contacts with civil society, with schools, and with other actors within society to disseminate and to discuss our research results. So you're very welcome to this seminar, but above all also, of course, to other activities. You're on our mailing list now as you are attending this, so you will be stalked by us in a modest way to invite you to other events that we will be organizing in the next 2 years and hopefully longer than that. Please also have a look at the website. I think in the invitation and the mail that contained the link to this seminar, you will find the link also to the STRATEGO website where you can discover more of what we do and with whom we cooperate. So thank you again for being here. I'm not going to take any more of your time so that we have plenty of time to look at the content, and I'm very happy that Frederik and Andreas are going to present their research results and discuss them with you. So over to Sophie again, and thank you for joining us.
Yeah, thank you, Peter. So, as I said in the beginning, the first webinar is about debating EU and international environmental policy, and specifically we will explore the key stages of EU and international environmental policymaker, including agenda setting, as well as some practical challenges that may occur during implementation. We will first discuss how interest groups shape the EU's political agenda, and then the role of environmental conflict resolutions. So our first presentation of today is by Frederik Stevens. Frederik is a PhD student and teaching assistant at the Department of Political Science here at the University of Antwerp. And his research focuses specifically on interest groups, money and networks in politics, and EU public policy and politics. Today, he will present a compilation of his work on how interest groups secured influence over the European Green Deal agenda. So, Frederik, the floor is yours. Please share your presentation.
Yes, great. Many thanks, Sophie. Let me check if I can get the slides on the screen. If you could just perhaps confirm that they are on.
We can see your slides perfectly.
Wonderful. Okay, just a second. All right, so thank you everyone for joining us on this webinar on EU environmental policy. As Sophie already nicely introduced, so my name is Frederik Stevens. I'm indeed a PhD researcher and a teaching assistant at the University of Antwerp at the Department of Political Science. And in my doctoral dissertation, I focus on lobbying with a specific focus on the ability of interest groups to secure influence over the policy agenda with a specific focus on the European Green Deal. And to kick off this presentation, I would like to take you back 5 years ago in 2019, when the incoming Commission revealed its new policy agenda for addressing environmental issues under the heading of the European Green Deal. So this was a comprehensive policy agenda comprising of multiple policy initiatives with the main aim of making the EU climate neutral by 2050. And as I said, so this agenda encompassed, of course, a wide variety of different initiatives across various policy domains, including energy, agriculture, industry, and of course, environment as well as climate. However, before determining its policy priorities for the next legislative term, the Commission was confronted with a multitude of different policy issues that could be addressed due to calls by various actors within the EU political system. So many actors, they called upon the Commission to do something about a variety of issues, such as deforestation, also pesticide usage, offshore wind farms, waste generation emissions, and so forth. But of course,
Frederik, I'm sorry, you're muted, sorry. Yeah.
Whoops.
Yeah.
Can you now hear me?
Yeah, we are fine. Yeah.
Okay. Did you miss anything or?
Just, I think, the last sentence, maybe.
Okay, perfect. So just like any national government, as I said, the Commission, cannot address all these policy concerns. So it needs to, engage in what we in the academic literature call strategic agenda setting. What does this mean? The Commission needed to make some decisions regarding, on the one hand, which issues to prioritize, and that would become a policy priority for the next legislative term, but also which ones it could not address due to, of course, there's scarce time, scarce resources, and institutional constraints that, of course, force the Commission to engage in what I call agenda setting. And of course, this process is often quite challenging because on the one hand, the Commission needs to decide which issues to include. And one of the issues that was included in its policy agenda, one example, would be the charging infrastructure for electric trucks, whereas many other issues were actually excluded from the policy agenda. So they were intentionally left unaddressed, despite some actors calling upon the Commission to address this issue. And one of the examples of the issues that was unaddressed, for instance, would be the export of polluting second-hand cars to developing countries, which, of course, one can think of potential consequences of this. But this issue, despite some advocates asking the Commission to do something about this issue was excluded from the European Green Deal. In this regard, so this agenda setting process in general attracts, of course, a wide variety of different interest groups. So both business groups as well as NGOs, they try to secure their interest at the earliest opportunity and trying to advance their interest at the beginning of each legislative term. So many NGOs, of course, were actively engaged in trying to influence the European Green Deal agenda Some of you might recognize here on the slide. So quite some notable examples here are Greenpeace, WWF, Transport and Environment, that of course ask the Commission to address issues such as deforestation, CO2 emissions, and so forth, while also at the same time asking to continue the existing environmental protections that were already in place. At the same time, also a variety of different business groups were also engaged in lobbying efforts to protect, for instance, the automotive industry, agricultural sector, and so forth, and try to steer the Green Deal in a favorable direction that would benefit their member companies. And in my doctoral research, I try to explain this, right? So the extent to which interest groups can actually achieve agenda setting influence, with a specific focus here on the European Green Deal. And that includes two elements, I think. On the one hand, it includes the ability to push favorable issues or dream issues on the agenda, right? So issues that could result in favorable policy changes, while also at the same time keeping nightmare issues or issues they heavily oppose off the policy agenda. And to answer this question, I conducted 4 different data collection steps. So on the one hand, I conducted interviews with European Commission officials, conducted a content analysis of different media articles of EU news outlets, conducted a lot of interviews with interest representatives, lobbyists from both business groups as well as from NGOs. And then finally, I also drew upon the data from the European Transparency Register. And this resulted in a database that provided insights on the one hand on 65 policy issues that all varied in their agenda status. So some of the issues, they entered the agenda and became a policy priority, whereas also others, almost 50% of them, they were not addressed, so intentionally left aside. And what you can see here on the slide is the distribution of these policy issues across different policy domains. So as you can see, a wide variety of different policy domains that were discussed. And also within each policy area, you see that this variation between issues that were tackled, but also some issues that were excluded from the scope. Next to that, I also collected information on the lobbying efforts and the characteristics of different interest groups that were active on these 65 policy issues, information of over 300 interest groups, more or less equally divided between, on the one hand, business groups and on the other hand, NGOs. And of course, I would assume that many of you are here to hear the first results. So let's take a look. I think one of the main questions many of you may be wondering about is, of course, which interest groups were more successful, right? So which interest groups were more effective in determining the agenda? And if you ask this question, I think many of you may assume that business groups actually are more dominant in terms of agenda setting because of potentially various reasons, their financial resources, their expertise on the policy topics that are being discussed. And also what we find in existing research is that these organizations often have more contacts with policymakers and are therefore also more likely perhaps to secure influence. However, the statistical analysis that I did actually indicate that surprisingly, NGOs were much more effective, especially when they secure media attention for the issues on which they mobilize. They are significantly more influential when compared to their business counterparts. And arguably, I think this can be attributed to the increased politicization of EU politics and public policy. And this is particularly true, I think, in the case, if you look at the Green Deal agenda, which addressed quite contentious issues. Think about pesticide usage, think about farming processes and so forth. And under these conditions, NGOs can actually be expected to thrive because they are arguably better at presenting a political message, meaning that they are better able at highlighting the representativeness of their cause to show public support or societal support for their position when compared to their business counterparts. So this is a potential reason why we have this finding. Then next question, of course, is not only which groups were influential, but also which ones or basically how they achieve this influence, right? So through which lobbying strategies can interest groups actually steer the policy agenda in a favorable way? And first, I looked at the different arguments that these organizations can use in their interactions with policymakers. And on the one hand, what they could do is focus on pressure information, on delivering pressure information, meaning the extent to which they are supported by other actors, citizens, as well as NGOs. So here I included on the slide two examples of this pressure information provision, where both Greenpeace as well as WWF on the issue of deforestation emphasized that an overwhelming majority of European citizens supported action on this issue. And also a lot of other NGOs were vocal on this and pressured, stood behind them. So this is a clear indication of how they can use pressure politics, so to say. Another option is that they go for expertise-based provision, meaning that they want to show how knowledgeable they are about the issue that they're addressing, right? So they can, for instance, refer to legal overlaps, such as here indicated by this example, or the potential economic impact of addressing a certain issue, technical aspects related to, for instance, supply shortages and so forth, or administrative logistical burdens. So these are two clear examples of how interest groups can focus more on expert information when compared to pressure information. And of course, the question is which of one of the two is more likely to secure or provide you with agenda setting influence. And in this regard, I think the main results of both the case study as well as the statistical analysis show that when interest groups prioritize this pressure information, right? So emphasize the scope of support that they enjoy, they're overall more effective when compared to organizations that mainly rely on this expertise-based provision. And I think this example on deforestation clearly highlights this finding. So as you can see, Frans Timmermans, who was actually defending the decision to prioritize this issue in the European Green Deal agenda, he argued that there was quite a lot of support from citizens to address this issue, and argued that every consumer in the EU should know where their products that they buy, where they come from, and whether they contributed to deforestation. However, once the issue entered the agenda, the picture was slightly different. So when it comes to addressing the issue and developing potential solutions on how to address, for instance, the issue of deforestation, the focus shifted. And what we have seen is that organizations that prioritize this expert information during this stage were actually more effective in downscaling the ambition of the proposal. For instance, by making sure that the scope of the regulation was restricted to only a limited set of what we would call forest risk commodities. So many other commodities were excluded from the scope. And also the scope was restricted to only forests, whereas other ecosystems that also potentially are in danger were excluded from the scope. And as you can see, these decisions were defended by the Commissioner for Environment by referring to the effectiveness of potential regulation, the enforceability, or the lack of practical experience. So here you clearly see the distinction between pressure politics in agenda setting versus more what we would call expert politics or technocratic politics when it comes to addressing different policy issues. Next, it's of course not only about what type of information you provide, but also how you provide it, right? So the way in which you communicate your arguments to policymakers. And in this regard, on the one hand, you can choose to go for an inside lobbying strategy, meaning you're trying to directly engage with policymakers and have a discussion by, for instance, providing them with a position paper, and you discuss that paper with the policymaker. Or you make a lot of noise by protesting, or by engaging in media statements, public statements, and so forth. So really trying to put pressure on policymakers in this way. And what I find is that the effectiveness of inside and outside lobbying strategies really depends on the goal of the organization. So if your goal is to push an issue on the agenda, a dream issue, if you're challenging the status quo, I find that if you engage in inside lobbying, so if you lobby it quietly, so to say, the chances significantly increase that you secure agenda setting influence, the more you engage in these direct interactions. Whereas if you engage more in outside lobbying, it doesn't provide you, or it doesn't yield you any benefits, because the likelihood of gaining agenda setting influence remains the same, regardless of how intensively you engage with in outside lobbying efforts. Now let's take a look at organizations that are trying to defend the status quo. And I find that somewhat surprisingly, it actually doesn't matter whether you engage intensively in inside or outside lobbying effort, because you're better off doing nothing. Because here, on the one hand, what you see is that it doesn't result in any higher chances that you can secure influence if you engage more in inside lobbying, whereas even you reduce the possibility that you can secure influence if you engage more frequently in outside lobbying. And I think this can be explained by the fact that if your goal is to maintain the status quo and keep an issue off the agenda, you also don't want to attract too many attention towards this issue. So arguably, you're better off staying passive and doing nothing. And then finally, final point, many of you, but then also in the media and in popular debates, may think that the policy agenda is influenced by, let's say only by interest groups, right? That they can unilaterally determine which issues enter the agenda and which ones do not. So here I included a couple of examples from media outlets in the EU on how single industries or single lobby groups were actually influencing the agenda. However, interest groups, of course, they do not operate on their own, but operate within a system where also institutional actors, as well as societal actors, they also play a role. And they have a crucial impact as well on the agenda setting process. So therefore, in this final part, I also analyzed to what extent interest groups can benefit from the cultivating support among other actors, but also when they are faced with opposition of these other actors, to what extent this constrains their ability to secure agenda setting influence. And I think three important actors need to be considered here. So political parties, of course, in the European Parliament, member states in the Council, and of course, EU citizens. And the results show, I think this is good news, that interest groups do not unilaterally or independently influence the agenda, but crucially depend on the level of support from other actors. So what you can see here is the more support from parties, member states, citizens, as well as other interest groups, the more likely you are as an organization that you secure influence over the policy agenda. While at the same time also your chances of influencing the agenda are significantly reduced when you're encountering a lot of opposition from any of these other actors. So that's said about the findings. I think there are two also important caveats that need to be addressed. So that are potential flaws within the research design. So on the one hand, issues that were identified as being off the agenda, so not included, they can, of course, still gain momentum later on in the policy process. So it's not because an issue is currently off the agenda that it cannot enter the agenda later on. And this is exemplified by the issue, I think, of wolves protection status, which in my data set was an issue that was considered by public officials as being off the agenda. But as you might have seen in the news recently, I think approximately 4 years later, the issue gained momentum due to arguably farmers' protests and so forth, and still entered the agenda, because now, indeed, it was decided that the protection status of wolves was downgraded. Another example is an issue that actually entered the agenda, but afterwards was still pushed back off or delayed. A clear example here would be the issue of pesticide usage, which, if you would read the European Green Deal agenda, this is an issue that is clearly mentioned. However, what we have seen is that agricultural groups and pesticide lobbyists effectively managed to keep this issue off the agenda by convincing the EC not to include it in its policy priorities. So that's it from my part. If you are interested, please feel free to reach out to this email address. The presentation is based upon a couple of publications, so if you're interested, you can find them on the slide. And of course, I'm now very interested in questions, comments, reflections, and so forth. Thanks a lot.
Thank you, Frederik. So indeed, it gave us an overview of the interest group lobbying process. So I wonder, are there any questions for Frederik? If you do have a question, raise your hand or put it in the chat so that we can see. I don't see any questions right now yet. Everything was very clear. Yes, Lisa. Please take the floor.
Thank you, Frederik, for the very interesting presentation. First, I have a very small question, just because I didn't get it really well during your presentation. I was wondering if your data allowed to know whether NGOs or business groups are more influential in the second part, in the problem-solving part.
The answer would be no. So the focus within the dissertation was clearly on the agenda setting stage and not follow up later on. So if issues enter the agenda, to what extent we can there see differences. However, I think what we know from previous research is that in these later policy stages, especially when it comes to providing this expertise, right, we can expect that business groups are more effective, as illustrated, for instance, by the case study that I did on deforestation, where you see that these business associations, even though the issue entered the agenda, they managed to downscale the ambition in the policy formulation stage by supplying technical arguments related to the economic impact, legal overlaps, and so forth, which were also clearly picked up by policymakers. This is, of course, only one example, but I would assume that also in other cases, this would be applicable due to the demand of policymakers of this technical information. They heavily rely on it to develop efficient and effective solutions. So this is, of course, a bit guessing work. I cannot say it based upon the data that I have, but also if you think about the existing literature, I think there are reasons to expect that patterns of interest group influence may depend on the policy stage.
Thank you.
Thanks for the question, by the way.
And we have a raised hand by Pranay Kumar. So go ahead, Pranay, with your question.
Can you hear me? Thank you.
Yes, we can hear you perfectly.
For the very good, insightful presentation. And of course, this agenda setting is very much important from the part of as a part of policy making processes. But do you think that these processes, when we take it as a broader picture, will those processes be impactful in changing the broad and European Green Deal targets or the outcomes of the final policies? So in your opinion, because normally the energy models, they do not account for all these processes. So I'm interested in what will be the possible impact on the final outcomes and their deadlines. So if you can.
Yes, of course. And thank you. Thanks a lot for this question. I think it's important to emphasize that agenda setting is where the policy process kicks off, right? So this is exactly the point where issues, the variety of different issues that are raised by many actors in the political system, that be it national governments, be it the Commission at the EU level, it needs to select which ones it will address. At the same time, that means that many other issues that are not subject or do not become a policy priority in the agenda setting stage are not addressed. And I think this is a crucial element of policy making, which is difficult to study, right? Because oftentimes the Commission will not publish documents on the issues that they're not addressing. They will, of course, outline their policy priorities and the ones that they are addressing. And a second point, I think, that is also important to mention, as I think I reflected a little bit upon in the caveats, is agenda setting is one thing, but it does not mean that ultimately the ones that have pushed the issue on the agenda would also achieve their preferences later on, right? So I think that's also an important consideration that after an issue enters the agenda, the Commission still needs to propose, needs to think of potential solutions. It needs to go to the co-legislators, the Parliament and the Council. And there, of course, a lot can happen as well. So it can go in different directions. And also their interest groups can play an important role. So I think it's important indeed not to look only at agenda setting in the first place, but also explore other potential avenues on how policy making can be changed, either before or after, right? Hope that more or less answered the question.
Yeah, thank you so much.
Okay, great.
Okay, we have another question by Tamika Dartnell-Moore. Please go ahead, Tamika.
Hi, thanks Frederik, for your presentation. It's really interesting, especially as a former lobbyist myself. It's nice to see an analytical perspective. I was just wondering, did you consider in your research, the different types of activities that NGOs versus business groups versus lobbyists for both of those sections employ, and how that might affect the results? Particularly, did you take into account the impact of the less transparent actions that lobbyists might employ that might be outside of the public eye, and how that might affect your research?
Yes, I think this is an excellent question. I did indeed look at this. So now what I try to explain is, of course, the influence that they achieve, but one could also look at potential differences in different strategies that different types of groups employ. I also looked at this, and what we see, and this is in line with what we know from existing research, is that NGOs, I think this is in line also with the findings, is that they are also the ones that engage more in these pressure arguments outside lobbying efforts and trying to build pressure upon policymakers to listen to them. Whereas business groups, on the other hand, they are on average, not always, but on average, they are more likely to engage in inside lobbying efforts, so behind outside of the public spotlight, so to say, and also engage more in this expertise-based lobbying. And in this regard, I think the findings, they reveal that both these pressure strategies are, and as well as the organizations that use these strategies, they are more effective in securing influence. I hope that more or less answered the question, in the sense that different groups, yes, they do definitely engage in different types of lobbying efforts, both in terms of the arguments that they use, as well as in the way in which they communicate them to policymakers. And this also has important, it has important consequences of their likelihood of securing influence over the policy agenda. So I tried to analyze this in different stages. So first the groups, then the strategies, and of course the two are a bit intertwined, right? Because the NGOs are indeed more likely, as you said, right, to engage more in these grassroots campaigning, media statements and so forth, whereas business associations overall, right, important to mention this, are overall more likely to engage in these insider lobbying efforts.
Thanks.
Hope that answered the question.
So I don't see any more questions at the moment, so maybe we can move forward to the second presentation, and at the end, if there's any more questions for Frederik, don't hesitate to pitch in then. So our second presenter of the day is Andreas Corcaci. He is a senior researcher and Marie Curie postdoctoral fellow at the University of Antwerp, and his research incorporates political and legal aspects and focuses on multi-level governance, and specifically on questions of implementation and coordination in the environmental, in energy and climate policy. He recently returned from an extended research visit at Kobe University in Japan, so we're very happy to have you back here at the University of Antwerp, Andreas, and at this webinar, of course. And today, Andreas will present his work on European and international governance and implementation of environmental obligations. Andreas, the floor is yours. Please share your presentation with us.
Yes. Thank you so much. Yeah, thank you for having me back and having me here in this seminar. I will present something that is a little bit more abstract, so please bear with me. This is about environmental governance understood as the relation between legal obligations on the European and international level on the one hand, and their national implementation on the other. So, and this happens in the context of environmental damages that stem from industrial activity, but also the increasing impact of climate change, all while we do not have a specialized environmental court beyond the nation state. I will go into the theory a little bit and then show some preliminary empirical examples. First, just to briefly introduce or say that these contexts that I already mentioned also mean that the implementation of decisions on environmental obligations, be they legal or non-legal decisions, are also a means of protecting the environment. But we kind of lack in research the insights on, like, macro level insights on those kind of decisions and their implementation, especially across different types of ways of resolving non-implementation. So then in my research, I asked about the conditions of implementation of such decisions. And my research design is based on a so-called concept structural methodology, which is a methodology that uses formal logic and set theory to basically connect theory and empirical analysis. And you will see this a little bit later, how this works. And theoretically, I adapt insights on policy implementation in the EU, but also intermediaries to this question of international and European environmental obligations. And the goal here is to provide a broad comparison of different decisions. And what I also do empirically is to conduct a temporal analysis, because I quickly observed that there are cases, especially court cases, that come with settlements that happen outside of the court case. And to capture these to some extent, I'm involving this kind of extra step here. And just to also make sure, environmental damage happens in all kinds of different aspects of social life, including war. This is a picture from Ukraine. I'm not focusing on this today, but I just wanted to also point this out, that it's not just about industrial activity in the narrow sense. And then theoretically, I start from policy implementation in the EU, as I said. And I focus on two academic approaches that have been pretty prevalent in implementation research. One focuses on the need to enforce compliance with rules and implementation against national unwillingness. This is called the enforcement approach. And a focus on national capacities, giving the willingness of the implementer to comply. And later, the literature kind of added a perspective that is more focused on moral obligations, norms, socialization, and so on. And this legitimacy aspect I subsume under the management approach, because it kind of enables countries to focus more on the capacities if they perceive the process as legitimate. So I focus on three important conditions: preferences, the mechanism to solve a non-implementation issue, and the perceived legitimacy. And this, I apply this through two explanations, which are derived from those approaches, but the empirical analysis doesn't exclude alternatives that might not show up in this model. Briefly about these explanatory factors or conditions. So preferences, understood as the political attitudes of the relevant actors, are shown to be important for implementation, but these include not only preferences as such, but also other related phenomena such as domestic conflicts, issues salience, which is quite important in many areas. But preferences are not expected to be the only explanation. So they're expected to occur in combination with other conditions. And one of those is the legitimacy as perceived by the implementer, because this can be seen as a less costly path than coercive measures to facilitate implementation by shifting the focus to the national capacities. So it kind of enables you to focus on assistance, on these kind of more cooperative interactions. And high legitimacy would then be expected to combine with positive preferences in the management regime. And then the other thing, the other factor is the strength of the mechanism that is used to resolve the implementation issue. And there we can roughly distinguish between formal, more confrontational, judicial sanctioning regimes, so court proceedings, but also more cooperative, so-called managerial mechanisms that are often exist in multilateral environmental agreements, so treaties that are not connected to courts necessarily. And those and here the expectation, theoretical expectation, would be that strong mechanisms are expected to combine with negative preferences based on the enforcement approach. And then I add another layer to my theoretical understanding, namely that of intermediaries. So intermediaries are important, as we've just seen in the presentation before, where NGOs and other actors can act as intermediaries in policy processes. But what they're theorized as like go-betweens between different actors. But what I do here is I look at the relation between the legal obligations and implementing actors. So in that sense, courts and committees fulfill the role of intermediation. This is an description by the researcher. They don't think of themselves as such, but this is helpful to highlight their function and capacities. Because they have the expertise to make those decisions. They are independent actors, which belongs to the capacities of intermediaries, and this ties in with this management approach that I mentioned. But they also fulfill functions of monitoring and enforcement, which then as their role, and this ties in with this enforcement approach. And here you see how this concept structure looks like in practice. And on just focusing very briefly on the left side, you see these different combinations and theoretical expectations. These where legitimacy combines with positive preferences and negative preferences combined with the strong mechanism to explain implementation. And intermediation here is understood as the kind of underlying mechanism through which this happens. And empirically, then the question is, is this really able to explain like these kind of cases where certain environmental obligations are not fulfilled, damages are being done to the environment in contradiction to international treaties or other legal obligations. And in terms of cases, I focus both on courts and these kind of committee type decisions that happen in multilateral environmental agreements and different policy areas. So I use hazardous waste and chemicals with the European Court of Justice, water and air resource management with the International Court of Justice, and the protection of the marine environment with ITLOS cases. And then I match basically different multilateral agreements to these policy areas: the Basel Convention, Water Convention and Protocol, and regional fishery management organizations. And currently I have around 26 cases in my analysis. And I won't go into the details here, but just on the left side, I use public documents, so the documentation of the cases themselves, and then official statements by the involved actors, as well as scientific literature to gain like qualitative information on those conditions. And I use a method called qualitative comparative analysis to analyze this. This is a method that's based on set theory and formal logic and not statistics, but it still allows you to incorporate different quantitative aspects to analyze a higher amount of cases. And just to provide a first overview of my very preliminary results. So I could reproduce the enforcement hypothesis, so the combination of negative actor preferences and a strong mechanism in all the models that I ran, but the results are rather weak because I lack currently court cases that come with actual strong enforcement. So all of my European Court of Justice cases did not involve the use of strong mechanisms. So this is why this explanation only covers 2 cases here, one of which I will go into briefly. And then I can also confirm what I call the extended management hypothesis. So this is the expected combination of positive preferences and high legitimacy, but it also comes with the presence of a weak mechanism. And this, I think, is a kind of a bias right now, because I don't have these cases from fishery management organizations that sometimes have stronger mechanisms, like, for example, regulation of fishing quotas and so on. And this is quite a strong explanation, because it covers a lot of different cases here. And then thirdly, the third result would be about the cases that have extrajudicial settlements. And this refers basically to a temporal mechanism where court intermediation, but also negotiations between the parties outside of the court case, led to a change in preferences over time, and in one case legitimacy, which kind of enabled this separate settlement of the case. And in the remainder of the time, I would briefly present some cases to provide a little bit more practical insights. So the first case is the enforcement through courts, and I chose the whaling in the Antarctic case before the International Court of Justice, where in 2010, Australia instituted proceedings against Japan before the court for large-scale whaling activities in violation of the Whaling Convention. And this led over time to a ruling by the court that basically ruled that Japan's Antarctic whaling program was in breach of the convention. But of course, this also meant that Japan, following the court proceedings, anticipated the kind of court's stance on the law, and continued activities under a new program. So they kind of complied with the core of the court ruling. They changed up their quotas, how much they fish in the Antarctic, to implement this ruling. But at the same time, they officially denounced the court's legitimacy in this context by basically saying that the court does not have standing. So they tried to find like a compromise in dealing with this. But and this is because these legally binding restrictions on so-called scientific whaling went against Japan's preferences. But interestingly enough, and this goes beyond my comparative analysis, different nations such as Australia and New Zealand kept up the pressure on Japan after this court ruling and after Japan instituted this new whaling program. And at some point, then Japan made the decision to actually withdraw from the Whaling Convention and to reinstate commercial whaling. Because this kind of process before the court still yielded an unwanted result for Japan. And this is something I could not capture in my broader analysis. And it only comes up in the case study, basically. And another basically typical case would be the management through a committee type structure. And I chose here a case under the Basel Convention where Bhutan was basically accused of non-implementation of reporting obligations under the Basel Convention. But of course, the Secretariat of the Convention and also the Implementation Committee, which is responsible for dealing with these cases, does not have the ability to impose any kind of sanctions or provisional measures or anything. So this was clear that this has to focus on a more managerial, like cooperative style of resolving the issue. And for that, the Implementation Committee provided lots of assistance, including financial assistance to set up a compliance action plan, but also provided expertise and training on inventories, on methodologies of doing reporting, which the representatives from Bhutan or the units within the administration did not have before. And although Bhutan was initially skeptical towards that, over time they started to implement those requirements, although it took nearly a decade. So it lasted between 2011 and 20. And then finally, In 2020, the compliance committee was basically happy with with Bhutan's progress. They submitted at least until 2018 their reports and completed this action plan. And this process kind of shows how this committee fulfilled this function as an intermediary by using different low cost managerial measures, but only against the willingness of Bhutan and also the perceived legitimacy of the whole process. Because if, for example, what happens in certain regional fishery management organizations where some nations are more or less have to be part of them, but they don't really regard them as the appropriate regimes to deal with the fishing quotas, for example, and there the legitimacy can be a lot, perceived legitimacy can be a lot lower. And then a third case about the extrajudicial settlement. So this is a case before the ITLOS, also again involving Japan, the southern bluefin tuna case, where Japan sought to increase their fishing quota despite very low tuna stocks, historically low tuna stocks, and argued strongly against the case brought by New Zealand. But in the end, the parties actually found a compromise outside of the court proceedings. So here's a quote from the literature where it's again shown how Japan disputed the ITLOS's jurisdiction in the case as such, and also the arbitral tribunal that was set up by the court, and they tried to basically shift the resolution of this issue to negotiations outside of the court. The ITLOS, in their first judgment, ordered Japan to reduce the tuna catches, and that there could not be any environmental fishing program. So these were significant provisional measures. But interestingly, the tribunal that was set up to deal with the details later declared that it actually does not have jurisdiction in the case and revoked all those measures. So this basically means that the case was kind of in nowhere land. So Japan and New Zealand continued to negotiate over the issue, and then they found a compromise that actually abolished the environmental fishing programs and also modified the fishing quotas, not as radical as the ITLOS wanted it to be, but still it was based on the order of the court. So the court here acted, again, in my interpretation, as a kind of intermediary and basically provided a way out, even though it was not found within the court itself. So we didn't have any kind of implementation of before the settlement, because the court case was not finished, basically. But then we found a compromise afterwards. And this kind of highlights this case, how these the intertwined intermediation, but also these negotiations outside of the court led to a separate settlement. I will skip this part and come to the conclusion because I'm already close to the 20 minutes. So to conclude, in terms of research, I think that linking these two approaches with legitimacy and intermediation arguments helps to reproduce certain explanatory mechanisms, functions, and also kind of the actor's strategic action in this context. And while two of the expected explanations were partly at least confirmed in the preliminary analysis, much more has to be done and much more detailed analysis, of course. But I found interesting that the kind of dynamics between these extrajudicial settlements can be highlighted in the analysis as well. And practically, to close, I think this research can help to feed into other disciplines by providing a new perspective to think critically about environmental governance. And also legal scholars, and this project is kind of also there to provide legal scholars with a way to do more than doctrinal legal analysis when they do it in empirical research, but have a kind of framework to look at different aspects that might not be talked about as much in legal research. And finally, the research, I think, highlights these kind of combinatorial nature of explanations and the role of intermediation, which might provide new insights that go beyond the scope of the everyday work of involved judges, lawyers, but also national administrators. Thank you so much.
Thank you, Andreas. Very excited to see what you're working on. So any questions from the audience for Andreas at this point? Again, raise your hand or type your question in the chat if you prefer. Andreas is ready to answer.
I do have a question if no one else has.
Sure, please go on.
Thanks very much, Andreas. It was also very interesting. I guess I have more of a practical question because I'm wondering then, did you manage to get the most optimal combination to ensure enforcement?
So, well, so what I did in so far was more or less test this kind of theoretical framework, right? And right now, I mentioned already that this enforcement hypothesis there is a solution that confirms it. So basically that means my cases don't contradict this expectation, but I can also only explain two cases with this, right? So there is a first indication that either, and this is my expectation here, that I'm missing these typical cases a little bit. Right, so all my most of my European Court of Justice cases have these extrajudicial settlements. So I don't have like the typical CJEU case where you would have, you know, a member state does not comply with some European legislation, and then there is some kind of you know, pretty strong enforcement done by the court. I mean, in certain areas, it has the ability to impose fines and so on. So I don't have any of these cases, but I'm trying to include more cases to see whether this explanation is helpful. And then maybe the second aspect is that I think these kind of case studies, and especially going deeper into these extrajudicial settlements, also helps me to get some additional insights on other conditions that might be important on this macro level. So right now, I'm not explicitly looking at the national capacities, right? I use the management approach to highlight how the focus on improving capacities is enabled. But I'm not looking at, okay, what can the nation state actually do? For example, you know, a country like Bhutan has low resources in that area, and so it might not be surprising that they take so long to implement it. But I'm highlighting something else here. And so I will still run other analysis that also include, for example, these kind of negotiations, even in the cases where the court resolved the issue, just to check. But you know, this is a macro level thing mostly, and also a theory test kind of approach. Yeah, thank you.
I guess I had another question if we have time. But maybe it's really quick actually. I was wondering, in your cases, do you have any case of like voluntary agreement between private parties that are not states?
So, I mean, this was obviously so far not. Let's put it like this. So, in the cases I have right now, there is one case. So there is the Client Earth versus Commission. Is an interesting case. I didn't talk about this here. Because it's a case where. And this is kind of also not part of the model really. It's a case where the Commission just found that the application of the law was already correct. So Client Earth basically filed a complaint about the authorization of using, let me look this up more clearly so that I don't say anything wrong. What was this again?
I was mentioning that because I'm also wondering if enforcement is maybe easier depending on the type of legal agreements that they have. In case of voluntary agreement between private companies, parties, I guess enforcement would then be easier than with states who are always negotiating.
Yeah, so I don't have any of these cases right now. If I would like to include them actually if they happen. So this Client Earth thing was about basically the use of certain chemical by recycling companies, right? And Client Earth basically questioned the Commission's authorization to use this chemical. But in the end, the court just said, no, this was fine. And there was no breach of the law, right? And Client Earth is known to be an actor who regularly litigates before the European Court of Justice to clarify stuff. So even though they have like counter-acting preferences, they made clear statements that they don't think this authorization should have been given, but they still accept the result. So this is also kind of a legitimacy thing. But it cannot be covered through my analysis because the case already said there was never any question about missing implementation, right? So these are also things that are then highlighted in the case study itself. Yeah. Thank you.
Okay, thank you. So if there's no further questions from the audience, I don't see any hands or questions in the chat. But I think, Andreas, from what I hear, there's still more work to be done by yourself, at least, to extend your case base a bit more. So there's undoubtedly some more results coming up in the future. So, and if there's still no further questions, then I think right now, I'm going to try to share again. Yes. I want to thank everyone for joining this first webinar of the Stratego Jean Monnet Center of Excellence. We hope you found it interesting, valuable. You have some inspiration for perhaps your work or your research. Please feel free to reach out with any questions or feedback you may have. And we look forward to seeing you at future events of the Stratego Jean Monnet Center of Excellence. And for now, have a great day. Thank you.
Thanks a lot, everyone, for joining. Bye-bye.